I had a case in the Criminal Division Court in Toronto, Old City Hall, in front of Judge J.B. Young. And this issue of the recording came up, where I'd been in court before, incidentally, and recorded in the Ontario Superior Court. So I simply said I want to take some time to set up the recording, at which point he balked and, "What do you mean?" And he didn't seem to know the law. So we argued through some 16 or 17 pages of transcript of the rights that I had to record, and I presented him with this pamphlet from Canada Court Watch that clearly sets out Section 136 of the Judicial Act. And as I say, we had quite a spirited argument, and he denied me the right to record, even though I brought to his attention that he didn't have the discretion to do that. And the result of that was that I then told him that if he was going to do that, he would have to make a formal order. So my charges were read, and he made a formal order that I couldn't record. I was offered a free transcript, which I thanked the judge very much for. And he said, "I hope that takes care of that issue." And I said, "Well, and the recording." And I said, "Well, no, not really. I still have the right to record." And that's the way it was left until after the adjournment.
So, on the first day of the, on your first court appearance, he denied you the right to record, but he gave you transcripts. Is that correct?
They gave me transcripts, yeah. He
Okay.
said he had been on the bench for 20 years and hadn't heard of this law. Well, the law had come into effect 2 years before he was even a judge.
So I understand you went back a second day, or a second day of your continuing trial, and the issue of recording was brought up again. So can you again explain what happened on the second day in regards to this issue?
Well, before I came back, when I left court, I wrote a 17-page, very strenuously worded letter to the Judicial Council, pointing out that Judge Young had acted as a tyrant and a judicial bully. And I didn't mince any words in that letter. And said that, again, you have the right under Section 136 to record your court case without argument, written or oral before a judge. So 3 months later, when I came back for the adjournment, it was quite a long trial actually. When I came back, things had noticeably changed. I went to court. I was going to ask him to recluse himself, and I was prepared to have a real battle with him. And his entire attitude had changed at that point.
Do you think that his attitude change may have been partly due to the complaint letter that you sent to the Judicial Council?
That's hard to say, but certainly something changed his mind. He said he'd been thinking about it, but what was interesting was he said, "Well, you did say it was only to supplement your notes." Like I'd only argued that about 15 times with him, but he said he had been thinking about it, and although I had had a transcript after 3 months, it was easy to get a transcript, but that I had several days in a row, and that he understood the point that I wouldn't be able to have a transcript, and so he was prepared to let me record. And at that point he asked me, "Did you bring your recorder?" And I say, "No, he told me not to bring it, so I didn't bring my recorder."
So what happened when he asked you if you brought the recorder? What was the next thing that happened in the court?
Well, it was pretty interesting because he could tell he was on the wrong side of the law here. And so he was trying to be very accommodating. So he said, "Well, if we had an adjournment, could you go home and get it?" Well, I brought to his attention, I live in Oakville, some miles away, and he asked again, "Well, could you have somebody bring it?" And I must admit, I just let him sort of stew there for a bit. And I'm convinced if I would have asked for a taxi to drive it here for $50, the court probably would have paid. His problem was he couldn't go on because he knew this was a violation of law. Therefore, he would be continually violating the law. So he was stuck. He just could not go on with the case. So I then suggested to him, well, look, Your Honor, why don't we have a recess and I'll go over to Eaton store and see if I can find another recorder. And he said, well, that would be fine. Yes, okay, sure. And so that's what he did. So I went over and got another recorder. The next day I brought my full equipment, 2 recorders and in case one fails, and 2 microphones.
So on the so at some point during the second day of your trial, did you actually get the equipment set up in the court and allowed to use it?
Yeah, I went over to the Eaton store, which is close by. I found a recorder and I brought it back, and there was no problem.
And he resumed the court at that time then?
Yeah, but he knew he couldn't do anything until there was a recorder because he realized it was a violation of the law.
After going through all this process of arguing and then being allowed to bring the tape recorder, did Justice Young ever bring any more objections, or was there any more debate about the recording device in the court?
Absolutely not. Quite to the contrary. When I came to the courtroom, he said, have you got your device all set up and ready to go? And, yes, sir. So no, he invited me. He made sure he invited me to make sure I had my recordings on.
So the judge became quite accommodating after that point.
He did, yes.
When it comes to other citizens in Ontario exercising their rights under the Courts of Justice Act, what would be your suggestions to them as well, should they have to appear before a judge in court?
To do exactly the same thing. To say, Your Honor, and without fear, to say, Your Honor, this is my right. It is in law. I have the right to record my case. And if he argues with you, then say, then you make an order. And when you have that order, then you have an order that is a violation of law. And then you take action. These are your rights. If you don't protect them, you will lose them. The unfortunate thing is we don't know our rights. But rather than that, it should be clear. Anybody that goes to court, a judge should say to them, as a matter of course, you have the right to record. They should be told that. Why should only the people who know the law basically have the right to record? It should be stated to them. You have the right to remain silent, as they explain to you. When you go to court, they will tell you you have the right not to take the witness stand. You don't have to speak out. You don't have to give any evidence on your own behalf if you don't want to. And you're explained that. You should be explained as a matter of course that you have the right to record. It should just be simple. What could be more simple than that?